Good morning, everyone. I welcome you all to the first technical session. Uh, Somsekhar sir, have you joined?
Good.
You're not audible. Okay, sir, can we begin with the session?
Am I audible now?
Yes, you're audible.
Okay. Okay.
Yes, sir.
Good morning to all
So,
of you,
sir, I'll
my
welcome you
fellow
first on
panelists.
I'll
Sorry.
welcome you first on behalf of
Yeah,
MNLU.
sure.
Yes.
Sure.
So, sir, I welcome you on behalf of MNLU Mumbai. First of all, thank you so much for accepting our invitation and being the part of the national conference today. So I take it as my privilege to invite our today's keynote speaker for the technical session, Mr. Somsekhar Sundaresan. Sir is a lawyer practicing as a counsel. Sir is a lawyer practicing as a counsel in the financial sector regulation, competition law, company law, exchange control relating to the litigation as the member of the committee set up by the Government of India, SEBI and RBI. Sir has drafted laws governing the takeovers, considering the trading and corporate governance of the bank. He's also actively involved in the drafting of the Indian Financial Code recommended by the Financial Sector Legislative Reform Commission. Sir is currently serves on the advisory committee of the Insolvency and the Bankruptcy Board of India on corporate insolvency and liquidation. Sir is the member of the Board of Studies in the Institute of Law, Nirma University, a member of of the Advisory Board of the Indian Law Review Journal, a journal on Indian law with comparative prospectus, teaches the security law, and is also a amateur mountaineer. So I welcome you on behalf of MNLU Mumbai. So you're not audible, sir. You're on mute. Just give me a minute.
Am I audible now?
Yes.
Yeah. Good morning to all of you, my fellow panelists. Mr. Thakkar, I don't think is back, but it's a pleasure to be here. It was nice to hear at the inaugural session about the work being done at the university for seminal discussions on corporate law. Happy to be part of it. Uh, while I was listening to the speakers in the morning, it was interesting to see references to lawmaking and the philosophy of lawmaking and the utilitarian principle of Jeremy Bentham and the maximizing the happiness for maximum people. And I'll try and sort of connect the dots to see how these play out in the context of corporate law. So I've been asked to speak on emerging trends in corporate law. And I think while we are at 2021, close to a little more than half a decade since the onset of new company law, the time is right for a review of how the law has worked. If we look at the New Companies Act and the manner in which the Act has uh, run its course since it was brought into effect, I think it is appropriate to reflect back and think about what is it that happened in society that led to uh, the need to rewrite company law, as it were, literally 60 years after it first came in the prior form. Of course, there were even prior company laws from 1913 onwards, but the 56 Act, the need felt to rewrite it and re-legislate it is something that it would be important to reflect on what transpired that motivated society to think about uh, new company law in the form of the 2013 Act. And therefore, to set context, I think it's important to talk a little bit about how the 2013 Act from a political perspective, had complete bipartisan support in Parliament. The act was literally piloted by a chair of a standing committee who was a leading member of the opposition, and the then ruling party was in the UPA. They all came together to write this law and pass this law. And in some sense, the corporate sector was caught napping because the corporate sector had not participated in the dialogue that led to this new law, in the smug belief that this new law will never come through. The numbers in parliament don't add up, and that there'll be a new parliament in 2014, and somehow this law will never come about. And on the eve of the expiry of the earlier Lok Sabha, the law did get passed, and we have the 2013 Act, substantial parts of which came into effect in 2014. Now, the law by design will always play catch up with society. I mean, even in our constitutional framework, the arrangement for Indian legal constitutional framework is that all acts of human ingenuity and human agency is free unless validly made law intervenes with reasonable restrictions. Therefore, when we look at company law playing catch up, it's nothing unique to the ingenuity of corporate action or the commercial world. In all areas of law, typically society will develop with its practices, society will develop with its beliefs, and where intervention is felt necessary, socially appointed lawmakers would come and create law. And the company law is no exception. So the Companies Act 2013 is a substantial change over the 1956 Act in a number of respects, and yet in its interpretation, one is still quite often reliant on principles and mindsets that have been hard set in the long tenure that the 1956 Act had. And that is something that will come up for conflict, that will come up for uh, review in the course of the next several years. And at some point, courts will start looking at departures made in the law as being significant departures rather than applying principles under the old law to interpret the new law. And in the course of my talk, I'll try and elaborate on what I mean by this. But there's one question I want to table and we need to ask ourselves. India is the third largest economy in the world in purchasing power terms. We really need to ask ourselves, does our company law render itself to be commensurate with this position of being the third largest economy? The infrastructure that we've built to administer this law, the means that have been placed at the command of those who implement this law, are these commensurate with an economy that is the third largest economy in the world? Is also a point I want to table for contemplation when we are doing such seminal work on company law. What one should remember is that when societal developments lead to such a development of a new law, very often across again bodies of law, nothing peculiar to corporate law, the lowest common denominator tends to become the norm for everybody. So far from moving away from the principle of utilitarian principle of the greatest happiness for the maximum number of people, to looking at the wisdom of whether a measure is right or wrong. If eventually what happens in the practice, in the political science behind lawmaking, is that if there is a most horrible case that came up in conflict with the prior law, provisions that would be made would often reflect the need to address those most horrible developments that were experienced. And in the course of that, those provisions become applicable to the entire society. We would see a range of these elements in the new Companies Act. Like company law, the new company law is popularly called the Satyam Law, because after the Satyam scandal was discovered and a lot of the developments of corporate frauds that came up between 2007-8 to about 2012-13, the belief that widely gained ground was that fraud is widespread, and therefore there needs to be serious interventions in terms of legislative inroads into business operations. And therefore, the new company law also sees a lot of elements of deep interventions by the state into the manner of conduct of business by companies, like interventions into even private limited companies, interventions into uh, the need for a specific structure of governance in a company, linkages to scale of a company rather than character of a company. These are all elements that you would see in the new Companies Act. And it is time to look at where we are headed when we look at emerging trends in corporate law. So, in this context, I want to first table how company law is criminalized under the new law and how the interplay of the criminal provisions in the company law would operate with the operational facets of company law. It's important to note that fraud in the Act is defined under Section 447. And that definition of fraud is an extremely wide definition of fraud. Any fraud in the course of conduct of the affairs of the company would be fraud and would invoke the fraud related provisions in the Companies Act. Now, when we look at Section 447, and if an offense is made out, then when you look at Section 212, subsection 6, there are two twin conditions imposed for the grant of bail when a charge of fraud is leveled under Companies Act. These are two twin conditions which are popularly seen in anti-terror law, which started with Tada, in Makoka, in PMLA, in the narcotics law, essentially saying that jail is the rule and bail is the exception. This twin requirement is that there should be reasonable grounds to show that the accused is not guilty of the offense under 447 and the accused is not likely to commit any offense if granted bail. So these two conditions from drug law have been bodily lifted and transposed into Companies Act. And these two twin conditions came up for constitutional challenge in the context of PMLA in the case of Nikesh Tarashan Shah, where the Supreme Court, in a very seminal discussion, held these provisions to be unconstitutional. After the Supreme Court ruling, amendments were made again to the PMLA, seeking to sort of reinstate it. And there are judgments of writ courts in a couple of writ high courts to basically say that the amended provisions do not revive the old understanding of what these two twin conditions were. Be that as it may, in the Companies Act, these two twin conditions remain, although identical in pari materia provisions in the PMLA have been struck down as being unconstitutional. Therefore, when a charge of fraud is made, the court which is considering bail has to be satisfied that there are reasonable grounds to show that the accused is not guilty. Now imagine at the stage of an arrest, where even perhaps the charge sheet would be a long time in coming, for a judge to become satisfied that the person is not guilty of the offense is a prime condition. And a second condition is that that person is not likely to commit any offense if granted bail. Effectively, this would make jail the rule and bail the exception. And this is something that one is dealing with in the running of a company. The running of a company is as sensitive as the being in a narcotics case is something, a sobering thought that I want to leave behind. And increasingly, this would be put to use and courts would come up with it unless the virus is under challenge. It's a statute that binds the court. And therefore, this is a principle that in a future trend is an area to watch out for as to how this provision of law changes its course over time. Will it become more stringent? Will it become less stringent? Is something that only time will tell. But if we go by recent trends, the direction appears to be going towards a greater degree of stringency. The same section 212 was amended in 2019 with a new subsection 14A, which enables an application to the tribunal, which is the NCLT, for disgorgement of the assets of any person accused. So, if it is felt, if it is accused that a certain person is guilty of fraudulent conduct and his assets or her assets should be taken out from their possession, an application may be made to the NCLT for disgorgement of the assets. So when we speak of emerging trends, and I was thinking about what are the trends that we have seen in the past several weeks or the past several months, increasing resort to section 212 14A, where applications are taken out for attachment of the assets of individual directors, individual employees, individual personnel of a company is being resorted to. This section uses the phrase without any limitation of liability. Now, that use of that phrase without any limitation of liability bumps up against the concept of limited liability company. And increasingly, the emerging trend under the company law is that the limited liability concept in running a company is merely a limitation of liability of the shareholder. But where the liability of the management is concerned, where the liability of the personnel of a company is concerned, that liability is to be put on an unlimited liability pedestal. And therefore, this is again a trend that I thought I should table for your contemplation as to where this body of law, where this facet of the law will emerge over time. Which also takes us to another interesting facet, also in the 2019 amendments. Sections 241 to 244 of the new Companies Act deal with operation and mismanagement. Now, operation and mismanagement has been one of the most long-standing facets of our company law through multiple rounds of legislation and the form of legislation that company law took. And it is a equity principle that runs in the operation and mismanagement provisions. Operation and mismanagement is in fact a concept where the principle of the greatest happiness of the maximum people, I mean, this phrase came up multiple times in the inaugural session today, or the utilitarian approach that so long as the majority of society is happy, the proposal that is sought to be adopted has good in it is simply put the principle Jeremy Bentham spoke about. Now, operation and mismanagement jurisprudence is in fact a check and balance on that principle. That merely because a majority believes that something needs to be done or something is even legally capable of being done, and therefore the majority wants to do it. The operation and mismanagement principle is a protection and a check and a balance against brute majoritarianism. Now, if you talk about majoritarianism in the conduct of a society being the shareholders, the stakeholders of a company, the manner in which members of a company come together to do business in a corporate form, the operation and mismanagement principles are a check and balance against that majoritarian ethos. So, something that is completely legal can still be oppressive and can lead to an intervention from the tribunal asking for a contract to be rewritten or contract to be cancelled or a action to be reversed. The powers are immense under sections 241 to 244. Now, in recent judgments, again, there is a tectonic clash. While interpreting operation and mismanagement principles, courts have continued to have resort to the majority rule principle. And they keep saying that if the majority believes it, can a minority question it? Can you question the wisdom of the majority? Now, if one simply adopts that principle, saying that the wisdom of the majority need not be justified on a principle of fairness and equity, then we can render 241 to 244 completely redundant, tie it up, and consign it to the annals of history, saying that they are totally irrelevant. One needs to ask oneself, is the new company law a measure of greater investor protection Or was the new company law a measure of diluting investor protection? Was it aimed at empowering minority shareholders and investors, or was it aimed at empowering, controlling shareholders and those who are in conduct of the affairs of the company? And these are questions that will need to come up and will need to be debated. As the current trend of the operation mismanagement jurisprudence goes, much is left to be desired, in my respectful opinion, because we are still dealing with old judgments of the 80s and the 70s. We're talking about Kalinga, we're talking about LIC versus Escorts, and the new modern environment in which corporate business is done in the country, in the third largest economy of the world. There is a disconnect between business conduct, oppressive conduct, and the administration of the law, which has been aimed at dealing with such conduct. But while on operation and mismanagement, I want to touch upon one other change that happened in 2019 when this element of 212 14A was introduced. 241 was also amended. And in the amendment to section 241, subsection 3 was inserted, enabling the central government to make an application to the NCLT to declare that any person who the central government believes is guilty of fraudulent conduct or improper conduct is unfit to hold any office in the company, which can lead to a 5-year ban from holding any office in the company. These are deep inroads, these are deep interventions that have been made into the conduct of the affairs of a company and the conduct of affairs of individuals who are engaged in the running of a company. So if an application is made under section 241(3), requesting the tribunal to declare that any person or set of persons are unfit to hold any office in any company for the next 5 years, it would be a corollary and it would follow that when such an application is made, and the application will also invoke section 212 14A, asking for disgorgement of the assets of those persons, asking for a declaration of assets of those persons, seeking a stay on transferability of assets of those persons. And if one looks at an emerging trend in corporate law, the filings in the NCLT are replete with such applications being taken out, particularly if a case becomes what can popularly be called a high profile case, where actions taken by people many, many years ago, actions taken by persons in subsidiaries of companies which are subject to oppression mismanagement, are all sought to be assailed to say that those persons running those businesses or in those subsidiaries, their assets should be declared and should be frozen, because it would be in aid of a future application for disgorgement of their assets without anything more to show as to whether they have personally gained or not from the fraud that is alleged. The governance decisions or the alleged failure of governance that a fraud took place can lead to two things. Those in governance of the company could be actively involved in the fraud, which would mean that they have connived, they have participated, and they are party to the fraud, they are the fraudsters. Or that despite their best efforts, fraud did take place. The systems were not good enough, in which case a case of negligence can be made out. But invariably, one finds in the administration of the law that a charge of negligence and a charge of fraud, which conceptually cannot coexist, are tended to be brought together and pressed at the same time. That if you're not guilty of one, you're guilty of another. And this is an element that one needs to bear in mind in the administration of the law. Then, of course, one goes into a whole range of jurisprudence on who is liable when a company is accused of an offense, right from Sunil Bharti Mittal's case to multiple judgments on the role of directors, etc. But increasingly, we find that the principle that got codified into the 2013 Act, which is to judge directors on the basis of their participation in board processes, that has been given the go by. If you do some sort of legislative history research, right from the 1990s, from a circular of the MCA to iterations in instructions to the officers of the ROC, the officers of the regional director, to codification in the 2013 law to say that directors' liability for wrongs that occur in a company must be linked to their role as discernible from their participation in board processes. Now, that participation in board processes, how is it to be discerned? How does one need evidence? How does one examine whether a director is liable or not? Is something that is yet to develop despite a range of jurisprudence being available, a range of judgments of the Supreme Court being available. In the first instance, every director, including independent directors, is arraigned as an accused by regulators galore. And when I say regulators in plural, I'm going to talk about other overlapping regulators who also administer regulations and law which run concurrent with Companies Act, and there is an overlap. So this is one area where I think one has to have some seminal discussions, and I would commend for MNLU's consideration far greater detailed research in the area of directorial liability and when does a director become liable. Because if we look at the governance framework, there's one other facet that must be looked at in the context of an emerging trend. There has always been a regulatory race between regulators in terms of how to regulate the governance of a company. If you look at RBI regulations, RBI has a whole range of things that directors of banks must do, that the boards of banks must do, including individual specific policies on HR and policies on placement of ATMs. There's a whole laundry list of what must be escalated to the board, and the governance of a bank will include looking at all of that, particularly for public sector banks. And there is a dichotomy there where non-public sector banks, which are pure companies under Companies Act, this sort of onerous governance requirement where the quality of the discussion in the governance of the bank focuses on the real big picture on policy issues rather than check the box of individual circulars which require the board to discuss specific issues. That has been commented upon by in the PJ Nayak committee, which reviewed corporate governance in banking. I would commend that for reading for those interested in terms of studying corporate governance and emerging trends in governance. But be that as it may, multiple regulators stipulate multiple parallel competing requirements as to what a board should do. Every sectoral regulator then says that our sectoral requirements requires the governance of the company to look at ABCD. Once it becomes a stipulative listing of ABCD items, then that becomes a manual, that becomes a check the box. And ultimately, you have a lip service of a discussion on those issues because the discussion is being had not because important governance requires it to be had, but because the law requires that discussion to be had. On the other hand, if we leave company law to develop from a tort point of view, most of the principles that has developed and has been codified into our 2013 law and is being further enforced in the manner that I've discussed so far are principles that have been picked up from other jurisdictions where those best practices developed from tort law. When a wrong decision is taken, when an injurious decision is taken, when a bad M&A transaction is effected or a good M&A transaction is abandoned, shareholders tend to litigate against the boards in those jurisdictions saying, you have caused us injury, pay up damages. So tort law has led to a range of good practices, best practices developing. What we have done, unfortunately, is we've simply looked at those best practices without an analysis as to how they developed and in what context they developed, in what fertile soil did it grow. We picked up the fruits and tried to plant the seeds here and try to codify that into mandatory law in our law. And in this dichotomy lies some of the inherent conflicts that need greater discussion, greater study in more seminars like this. Now, when we look at this sort of a situation where the governance of the board and the structure of the board is looked at by multiple regulators, it also brings with it one more element. The old section 55A of the Companies Act 1956 which talked about the division of powers between the Securities and Exchange Board of India and the official machinery that administered company law, the MCA, the ROC, etc. Now, we those who are on the wrong side of 40s, we still keep saying BCA, which used to be the Department of Company Affairs, which is now the MCA, the Ministry of Company Affairs. So, when we look at this division of labor between the securities regulator and the MCA, DCA, the new Companies Act makes it even clearer and empowers SEBI substantially without there being any confusion about who plays what role. But another trend that needs to be studied and needs to be looked at is a regulatory race between the MCA and SEBI on how to regulate governance. So when SEBI had its governance structure of independent directors, board committees, audit committees, NRC, etc., company law caught up and codified that into Companies Act. In the 2013 Act, everything that was part of the listing agreement and part of the listing requirements under SEBI on the governance side became part of Parliament made law under the Companies Act. But then the regulator, which originally drafted it, didn't want to be left behind. So SEBI drafted its own new regulations on related party transactions, which placed the related party transaction, the review of it, the approval of it on a footing higher than the footing stipulated in Companies Act. So this regulatory race, when last looked at, we're going to have a whole new overhaul of related party transaction governance and requirements relating to that, which will kick in this year for the listed companies under the securities regulatory framework. And if you study some of those, including how the term related party would be defined or the transactions would be covered, again, it goes a step beyond what company law requires to be done. And therefore, in this regulatory race, one really needs to sit back and ask oneself a question as to have we solved the problems that we desired to solve? While we write law, it's very important to sit down and say, what is the problem that we seek to solve? And then come up with a draft law, which is a suggested solution to that problem, and then put it to society to study whether this solution will actually work. Otherwise, we would have the satisfaction of saying that I will write laws which are good to have. I don't care about the impact of the law. Then, whether it really has good effect or not, one can study. I mean, a great example is the anti corruption law. India has the most stringent anti corruption law in the world, but one has to examine whether corruption is really curbed by that law. So, unless we study at regular intervals like this in half a decade or 1 decade, a deep, a deep review of the effectiveness of a law, a legislative impact assessment, is a very, very important exercise that must be taken. Seminars like this would start such a thinking, and I would think MNLU should take the lead in perhaps taking up individual facets of changes that have happened in company law and examine whether these changes have at all been fruitful, what can be done to better them, what are the enforcement issues that we find in them, are they clear, are they predictable for society to run business in a predictable manner. These are facets I wanted to leave behind for your thinking. Two other elements I want to touch upon before I conclude. One is the whole interplay between accounting and company law. Are all accounting frauds securities frauds, or accounting frauds are corporate frauds not being securities fraud? This is a question at large. According to the securities regulator, every accounting fraud is necessarily a securities fraud when it comes to a listed company, because the results and the financial position of a company is reflected in its accounts. If the accounts are manipulated, then the market is manipulated. Whereas the regulations which deal with it talk about fraud in the context of dealings in securities. Judgments are out both ways, saying that unless there is a link to dealing in securities, you can't invoke securities market fraud as a sweeping cover to all accounting frauds. While that issue gets dealt with by the courts and it winds its way through the courts, one other important question to bear in mind is whether auditors who audit the accounts would ipso facto, would per se become guilty of fraud for no reason other than having been auditors under whose watch a fraud took place. Again, the question of negligence versus fraud would be a fairly important element in the context of auditors. The Bombay High Court, in the case of Pricewaterhouse, had ruled that if the auditor participates in a fraud, there would be a jurisdictional fact for the enforcement of securities law against the auditor. But if the auditor has not participated in the fraud, if the auditor is negligent, then the regulator of the auditor's conduct would come in. On that front, also, there is an emerging trend. We now have the NFRA introduced through company law, and the NFRA is making deep inroads into the quality of audit, into the role of auditors. But a note of caution I would like to sound, and this will also merit a good study because now we have a rich number of orders passed by the NFRA. Are we missing the link between negligence and fraud, or do we go into the element of saying a long-term occurrence of fraud is ipso facto evidence of connivance in the fraud and one need not show more? I think that would be a dangerous arena for commercial law per se, because it would then lead to intention free fraud, which is a concept that would be a little alien. To defraud, one should have an intent, one should have a state of mind. But these are elements which I would think should be debated. One last point I want to make is that a very important instrumentality in the administration of corporate law is the National Company Law Tribunal. When we took away jurisdiction from the high courts, which have historically held the jurisdiction, and gave it to the NCLT, where of course you have all these various judgments now, right up to after Chandra Kumar, Sampath Kumar, Roger Matthew, the NTT judgment, Madras Bar Association. But these are constitutional debates to have. But I'm not so much on that. Let us assume for a moment the tribunals are here to stay, and the tribunals, as they have been upheld in the most recent judgments, are these tribunals being given the adequate and robust infrastructure to run and administer the provisions of company law? At last count, in the commercial capital of the country, it takes anywhere between 2 months to 6 months to get an order to convene a meeting of shareholders to consider a scheme of arrangement. If that is the state of affairs, if that is the pace at which M&A activity can take place, and if our tribunals are not well manned, well staffed, and they are unable to even pass simple orders convening a shareholder and creditor meeting for weeks on end, I'm afraid this third largest economy position that we hold in the world would be under serious threat. It's a matter of time that the effect of all of this, the burden of all of this, will come upon us. I think I'll stop there and see if there's any, I don't know if the structure enables questions or if it will be at the end, but I think I've come to the fag end of my allotted time. Thank you for listening to me.
Thank you so much, sir. If anyone has any questions, you can post it in the chat box. So we'll wait for 1 to 2 minutes if anyone has any questions.
सेक्शन है ना कि एक सेक्शन है मेरा सेक्शन
So I don't think there are any questions from the participants.
Yeah, that's fine. Thank you. I think
Thank you so much, sir.
bang on time. So
Yes, sir.
thank you for listening.
Yeah, thank you so much, sir. Okay, so moving further with the next technical session for the today's national conference, I take this opportunity to invite amongst us Advocate Gautam Sahi sir. Sir is the partner with Dua Associates, specializing in competition law and policy. He has been working in this field since the enforcement of the substantive provisions of the Competition Act 2002 in May 2009. He has extensive experience in formulating, strategizing, drafting information, appeals, replies, statement of claims, and etc., leading examination and cross-examination, representing the clients before the Competition Commission of India, National Company Law Appellate Tribunal, High Court, and Supreme Court of India. Sir also advises on M&A transactions with respect to the compliances with the competition law and also involved in MA filing and seeking approval from Competition Commission of India since the promulgation of the combination regulation in June 2011. Sir has also created and administered the competition compliance program for various corporate houses, which includes drafting compliance manuals and training for senior management. He has successfully planned and executed compliance audits, including national level mock raids, to check the compliance status of corporate houses. Sir has also represented the clients before the Central Electricity Regulatory Commission and National Pharmaceutical Authority. Apart from competition law, Sir has also been involved in policy work and given the opinion advisories to various ministries, Department of Government of India, corporate houses, and trade association on issues related to e-commerce, international trade, subsidies, WTO, and international bilateral and multilateral agreements. He has also represented various corporate houses, trade associations before the relevant government authorities on the issues related to draft policies and proposed legislation. Some of the key assignments of the Sir have been in antitrust litigation, combination filings before the Competition Commission of India. Sir has also been associated with Indian Institute of Corporate Affairs and CUTS Institute of Regulation and Competition. He is a resource person for both this organization for their short courses on competition law. Sir is also member and expert of the expert committee at National Academy on Legal Studies and Research University, Hyderabad, for some of its specialized programs, including its integrated BBA MBA program. Sir has co-authored a comprehensive commentary on Indian competition law, which has been published by Taxman Publications. Sir has also drafted study material on competition law for Competition Commission of India and conducts the modules on the competition law at Nalsar University, Hyderabad. So thank you so much for accepting our invitation and being the part of today's national conference. I welcome you on behalf of MNLU Mumbai.
Thanks for having me. Pleasure to be here. And that was quite a long introduction. I think next time I should cut it down a little. One of the best advice that I can give you is to continue or request Som sir to continue briefing you on developments in competition law. He's one of the finest counsels who has argued competition law matters, amongst other matters that he argues. He might not remember, but the first merger filing that I did was in 2011 for Disney, when Disney was acquiring UTV and Disney was Som sir's client. And subsequently, I've had the pleasure of briefing him, where he dismissed from one of my first contentions, thankfully, because of the knowledge of competition law and not ignorance of competition law, which is often the case. So, coming to the development of competition law, I have a short presentation. Let me start with that. Niraj, I'm not getting the right to share this.
Yes, sir. Can you share your screen now?
No, the share content is still not active.
Okay, just give me a minute.
Thank you for the kind words, Gaurav.
My pleasure, sir.
So can you share the screen now?
Yeah, I can. Thanks a lot.
Yeah, most welcome, sir.
All right, can you see the presentation?
Yes, sir.
All right. Now, if you look at the trend in terms of competition law, this has been a serious change in the way we have approached the competition in the market. I remember a case from 1980s where Bajaj was penalized by the MRTP Commission because it had produced, 1001 scooters on a production line which was authorized to produce only 1,000 scooters. So because it was more efficient, that efficiency was penalized. And to the present day, where the law encourages inefficiency, it encourages competition between players in the market. So there's a huge change in our approach to the market in terms of how the law is perceiving it. Now, I often begin my presentation with this statement. And just like they say that the law will follow you from your birth, from cradle to grave, competition law will follow you as long as you are indulging in business in the market. What does competition law regulate? And I'll just briefly touch on the specific area that the law is regulating and then go on to what are the most recent trends and how Competition Commission of India is behaving. What are the new developments in this domain? One, of course, is prohibits anti-competitive agreements. That is, prohibits cartels. It prohibits competitors to come and collude to harm competition in the market. That is, they come together to an agreement not to compete with each other, whether it be by price fixing or by any other means, or by bid rigging, etc. It prohibits abuse of dominant position. That is, a big guy out there in the market cannot harm others, whether it be the competitors or the consumers or his suppliers. So other players in the market, other enterprises in the market cannot be harmed by the dominant guy out there. And lastly, it regulates combinations. Combinations are basically mergers, acquisitions, and amalgamations, which cross certain assets and turnover thresholds given in the statute. Now, what has been the recent trend recently? There are certain industries which have come into focus, which are being looked at more carefully by the Competition Commission. It's not to say that CCI is not looking at other forums, but Competition Commission is having a closer focus on these industries. One is e-commerce, technology, and algorithm-based economy. Other is the automobile industry. And then let's look at the recent cases that have happened in these industries. Tech and e-commerce, I call this the return of prodigal sons because most of these companies began in small garages and they were protected by the competition law when they were growing. There were other big players. These were small, minuscule enterprises who were given the protection of competition law. Slowly, these entities grow. And that's the success of competition law. And this is what we have seen in West. That small entities, based on their technology, based on their quality, based on their innovation, have been able to grow big. And success of competition law in West is that these entities have today become the dominant guys out there. So as I like to say, that the success of competition law is whether you end up creating your own enemies or not. This is what has happened. So let's look at Google. All right. Google is under investigation. I have just brought up 2 cases, but there are multiple cases that's going on against Google. In January 22, new investigation has been started against them in the online advertising market. The complainants were the news publishers. They were the ones who approached the commission. What was their concern? The concern was that when Google is advertising on their websites, Google does not share the data. That is, what is the money that that Google is earning? What are the management practices? How the revenue is generated? How it is shared? So they just get certain percentage of the revenue. However, Google apparently, allegedly, is not sharing the process by which this whole revenue system is working. Other element was that Google has taken a unilateral decision not to pay the publishers for the snippets of the news used by them in search engine results. You will see when you try and search for certain news, you will get certain small paragraphs from different news outlets. This is called scraping. So you are picking out certain paragraphs, showing it in your search results. And apparently Google is not paying the news websites for this. And these are 2 major allegations, apart from a couple of others, that CCI is investigating now. Google is already under investigation in the payment systems market, and this investigation was started in November 2020. What were the major allegations? In this case, interestingly, the informant had sought confidentiality on his own identity. So we don't know who the informant was. The allegations were that when you are using Google Play, uh, when you're using a Google-based mobile, an Android-based mobile, and using Google Play, if you want to download an app or you want to make a payment for an in-app payment, you must use the Google payment mechanism, the Google Pay. You can't use other wallets. Second was that sorry, like I said, the second is that you very clearly Google has said that you can't use other payment applications or other UPI apps while making payments for any product, any application, or any kind of in-app purchases on a Google system. And lastly, search bias. So if you try and search for a payment mechanisms or payment apps applicable out there, then Google of course will show Google Pay as the first result. So there's a search bias in favor of Google Pay. Uh, Flipkart and Amazon are also under investigation. The traders, small traders in India, have been making a lot of noise about their practices, and recently, the government is looking at it. In this context, may I also point out that even in US, the President of the United States has issued a direction to the different authorities, competition authorities and otherwise, to look very closely at the tech sector and the e-commerce sector. So it's not only in India that we are focusing on these sectors. Globally, certainly there is a realization that we can't allow these tech and e-commerce companies to indulge in practices which may be anti-competitive, which may end up destroying their competitors in other industries in the markets. So Flipkart and Amazon are under investigation in the e-commerce market. This investigation was started in January 2020. Delhi Vyapar Mahasangh was the informant. What were the major allegations? One was the exclusive launch of mobile phones. Excuse me. This is something that you must have seen, that some mobile phones get launched exclusively on a particular website. It may be either Flipkart or Amazon. And this is something that is being questioned because there are other traders out there who would like to sell these products and make money. There's maybe small outlets out there who may be willing to do it. Maybe the online players who may want to sell those products. But these get launched on a particular, exclusively on a particular website. So that's under question. Next is deep discounting, also called predatory pricing, where the prices being offered by these websites allegedly are lower than even their actual cost of production. So that is being questioned, and because they have the requisite big pockets to finance this kind of activity, to offer these kind of discounts, the smaller players out there are facing problems. Preferential listing of and preferential sellers. So what they do is that if you see they have their own allegedly they have their own group companies or certain sellers who they prefer on their own website. So when you search for a particular product, the products being sold by their related entities or entities with whom they have their certain agreements, they get listed on top. So again, a kind of a search bias is there when you are looking for products on these particular websites. And lastly, I'm sure this is something that we all have heard and discussed, that WhatsApp is also under investigation for their privacy policy. When they came out with this new policy where they said that we'll be sharing data with Facebook uh, without the consent of the users, this is something that CCI is looking into. What will be the impact? And their concern is basically that this term is very unfair to the consumers. Apart from this, there are a couple of other cases that one can quickly look at. One is the alleged cartelization in the aviation sector. This was started in somewhere around 2017, 2018. And CCI suspected that in the aviation sector, while the pricing of the ticket is being done using certain algorithms, there may be some collusion based on these algorithms. And algorithmic collusion is a subject by itself in various very interesting ways of looking at how algorithm can be misused. And this is something which is worth studying. However, CCI could not find any requisite evidence of cartelization, and hence parties were exonerated. Make My Trip is also under investigation. Similarly, in fact, even Intel and Apple, as on date, are under investigation. Next is automobile sector, and that has had a very interesting story. It all started in August 2014 when CCI started looking at the conduct of players with respect to their market for spare parts and their services or the automobile services. And I want to start from that. That's where the trend started. And it all started again with the how the relevant market was defined. And the relevant market CCI said in this case was there's the market for sale of spare parts and repair services. As a result, CCI concluded that each brand is dominant, rather a monopoly in its downstream market for spare parts and repair services. So Maruti is dominant in the market for the Maruti spare parts and spare services, repair services. Similarly for other brands. So as a result, every automobile player ends up being dominant in the downstream market. But the problem here is the moment you're dominant, the compliance issues become really problematic. Anything that you do, even minor thing, should be checked from a computational perspective. You try and increase the prices, you try and decrease the prices, you try and give discounts, you try and decrease the discounts. Everything can be seen or must be assessed from a computational perspective. And this is what we see is happening right now. The abuse in that case was, of course, unfair pricing. CCI said that the charges on spare parts, the profit that the companies are charging on spare parts is very high. So that was a big concern. Then the second was restricting the ability of independent garages to compete in the market. Now, what was happening was that, of course, for some valid concerns like IP issues and providing spare parts which are not authentic, problem with respect to the quality of repair services being provided. For these reasons, the automobile players were not providing their authentic spare parts and diagnostic tools to the independent garages. And they were also saying that if you go to these independent garages, we are not going to, we are going to disregard the warranty that you have on your vehicle. Now, as a result, the independent garages claimed, and this is what CCI accepted, as a result, the independent garages were not able to compete with the authorized service centers of these automobile companies. In this context, CCI said that, look, you need to start sharing these spare parts, the authentic spare parts, with the independent garages. You need to start sharing your diagnostic tools with these independent garages. And apart from this, CCI also penalized the automobile companies. Now, as a result of this, now we see that there are a whole chain of cases in the automobile sector in which in the downstream market, these players are being treated as the dominant guy, or at least guys with high market shares. And then their conduct is being assessed by the Competition Commission of India. So then we see Hyundai case in June 2017. Sorry. In Hyundai case, again, downstream market, the issue was discount control mechanism. And Hyundai was monitoring the discounts which was being offered by its resellers, the authorized resellers. It was also trying to monitor the prices. Apparently, it was it had hired certain specialized agencies who used to go and monitor the prices out there in the market. So there was a resale price maintenance being done by discount control mechanism. And the idea of the commission was that the authorized service centers, authorized resellers of the automobile company should also compete with each other. And because the discounts were being controlled, this amounted to resale price maintenance, and there was a lack of competition between the authorized resellers of Hyundai. Second was tying arrangements. That Hyundai had said, if you want to buy CNG kits or lubricants or insurance, then here are the particular entities from which you are going to procure those. You can't procure from any third party. So this was found to be anti-competitive, and Hyundai was penalized. May I just also point out, but that this order was set aside by the NCLAT, and right now this is before the Supreme Court of India. Then there was the Maruti Suzuki case in August 2021. It was a suo motu case. Somebody wrote a letter to the CCI, rather an email to the CCI, and CCI decided that this is something that they want to look at. and they want to have a closer look at this issue. So they took up the matter, started an investigation, uh, and I must say that there are very few cases where CCI takes suo motu action. This was one of those. What they found was Maruti was also indulging in a discount policy. So Maruti was telling its resellers that you can't offer discount beyond a particular price point. And if you want to offer that discount, then you must come and take a no objection certificate from me. You must take my consent before you can offer higher discounts. And if you do that, if you offer discounts without taking my permission, I'm going to penalize you. CCI found that again there was an element of price monitoring where they had hired agencies to go and monitor the prices in the market. Next was the issue of market power. Because like I said, the moment you say in the downstream market, you are the dominant guy out there, there are concerns with respect to your market share. But in this case, CCI said even in the overall normal vehicle market, the consumer vehicle market, Maruti had a market share of around 50%, passenger vehicle segment. So it was a reasonably big player out there. And as a result, the impact of their conduct on competition in the market was substantive. So what are the two effects that CCI looked at? One was that there is a reduction in the inter-brand competition. That is, once I know in the market that Maruti is, let's say I'm Toyota and I'm the competitor of Maruti, of course, and I know that there is a discount policy being implemented by Maruti, I know the price at which it is being sold in the market. So when I go and price my products, I'm not concerned. I know the price. I know that he'll not sell that product beyond a particular price point. So I just need to keep it at that level or slightly below that level. So this strategic uncertainty that we say in the market is lost as a result of this. Hence, there is a lack of inter-brand competition that's happening in the market because of Maruti's discount policy. Second was, of course, the lack of intra-brand competition. That is, the authorized resellers of the Maruti were not competing with each other because they knew that there is a price policy. My competitor in the market, who's also selling Maruti products, will not sell the product beyond a particular price point. So I don't need to compete with him with respect to prices. Hence, Maruti was also penalized. And lastly, Tata Motors is also under investigation. This started in May 2021. The allegation there is that Tatas are forcing their resellers to order cars from them. There is quantity forcing happening there. It's not that the resellers are taking an independent call with respect to how many units of a particular car they want to procure, which they can sell in the market. Rather, Tata decides how many cars they should procure from Tata. There have been allegations that Tata kind of takes their letterheads and writes what are the units to be procured and then makes these entities sign it. Second is there is an allegation of that Tatas are restricting these resellers from entering into any new business, irrespective of whether that business is with respect to the automobile sector or something else. They're saying if you want to do it, you need to take a NOC. Otherwise, you can't indulge in any new business at all. These have been found prima facie to be anti-competitive, and CCI has directed an investigation, which is continuing as of now. May I also point out that till now this has happened in the automobile sector with four-wheelers, but the principles are such that you can expect that similar cases will arise in the case of two-wheelers, in case of farm equipments, similar sectors where they're in the downstream market where spare parts are to be used. CCI may apply the same principle to say, look, in your downstream market for spare parts and services, that may be printers, that may be computers, that may be other machinery, where in the downstream market, the spare parts are being provided by the original equipment manufacturer. In all these markets, this principle can be made applicable. So we can expect that similar cases would come up before CCI in future, and this is something which is not going to stop right here. No, something that we have seen in recent times is that CCI has been quite aggressive against cartels. Initially, if you read the orders of 2011, 2012, CCI was apprehensive about its own capabilities. It was apprehensive about its own investigation. And so you see this language where they say cartel-like conduct. So they used to, you see, in the competition law, there's the penalty for cartels is much higher than the penalty for any other anti-competitive activity. So keeping that in mind, CCI used to say, look, these entities have indulged into an anti-competitive cartel-like conduct, but then go ahead and penalize them for normal anti-competitive conduct, not cartel penalty. But from there now we see CCI, there's a lot of confidence which has come into the regulator, where it is sure of, is much more sure of its own investigation reports, and is willing to get aggressive with these cartels. So let's look at a couple of these cases. Automobile bearing cartel, June 2020. The cartel was formed by NEI, Schaeffler, SKF, and Tata Bearing. Uh, Parties allegedly met and discussed price revision and minimum percentage of price increase to be quoted to the OEMs. So then they were supplying these bearings to the automobile manufacturers, they discussed the prices and what is the prices to be offered. However, they did not implement this because the actual quotes that they offered to the automobile sector were different from the quotes that they discussed during their meetings. However, CCI decided that look, there was still a cartel. They said it was likely to have caused a appreciable adverse effect on competition. So they decided, they concluded that look, there was a cartel. Though they decided not to penalize these entities, they still concluded it was a cartel. Next is the beer cartel case. This is September 2021. The total penalty that was imposed in this case was some 870 crores. And the cartel was allegedly formed by United Breweries, Carlsberg, Anheuser-Busch InBev, and on the platform of All India Brewers Association. Now, what CCI ignored in this case, and that's why I say CCI is becoming more aggressive, is that there were certain pressures which were exerted on these parties by the buyers in the market. Buyers were basically government authorities and public sector undertakings. Now, there was certain pressure being exerted, and this is what the party said: like, look, the environment that is being created around me is harming me. Okay, that is why that's what has led to cartelization in the market. However, the Competition Commission of India completely ignored this and decided that no, there was a cartel and penalized all these entities. Important element here that end user filed leniency in this case and confessed that there was a cartel in the market. So no penalty was imposed on end user. Next is that we see that there is a certain amount of leniency being shown towards MSMEs. And I think that's a positive thing, because there is a recognition of not only about MSMEs, but recognition that there are tough financial times that these MSMEs are facing during the COVID. So we see cases where the Food Corporation of India had initiated a case where again there was a case of bid rigging. The OPs were found to be indulging in the case in bid rigging. They were quoting prices by coordinating with each other. But CCI decided not to penalize any of them because one, they were MSMEs. Second was that they were they were facing tough times because of COVID. Next is the Mercers India case, again in November 2021. OPs were found to be guilty of indulging in bid rigging, again with respect to Southern Railways tenders. Again, CCI decided no penalty to be imposed because one, they were MSMEs and tough financial times. So we see that CCI, they are not just following the law. There is a recognition of what's actually happening in the market, and that is what is expected from a competition regulator. There is a requirement of acknowledging what's happening in the market, and this is what CCI has done. Lastly, there was a lot of concern in the beginning when CCI started prosecuting cases in 2009. The concern was that whether CCI would be willing to act against the public sector undertakings or ministries of the government or departments of the government. What we have seen is, while this was to an extent true in the initial years, recent years CCI has said nothing doing. We are going to look and prosecute the government entities as well. Most recently in January, I think this is the order of 7th January, where CCI has started an investigation against a PSU called IREL, which is is effectively a statutory monopoly. It is in the market for beach sand sedimentite BSS. Allegations were that they are arbitrarily increasing prices over a period of 4 years because there is no other competitor out there, so they can increase the prices and they'll not lose consumers. And they're engaging in discriminated pricing by selling BSS to domestic buyers at a higher price than foreign buyers. So these two main allegations are there. Private CCI has concluded that these are violations of competition law, and CCI has decided to investigate this matter, and let's see how this comes. But prior to that, CCI has shown a very clear inclination and willingness to prosecute PSUs. They have penalized oil marketing companies for cartelization. They have penalized insurance PSUs for cartelization. They have gone after Coal India Limited, one of the highest fines for abuse of dominant position. And they have also gone after Ministry of Railways. I remember I was part of this matter involving Ministry of Railways. The Railways were saying, look, we are a ministry. We submit a budget before the parliament. What are you saying? You can't have jurisdiction on us. But CC said nothing doing. We have jurisdiction on you because you are indulging in a commercial activity. This matter went all the way to Delhi High Court, and Delhi High Court said the same thing, that Ministry of Railways was indulging in commercial activities and hence was subject to the jurisdiction of the Competition Commission of India. Now, something very interesting has happened in the recent times, and in December last year, CCI penalized Amazon a total amount of 202 crores for suppressing the real objective of their combination when they approach CCI for the approval. So this is the case where Amazon was acquiring certain shares in FCPL, the future company. According to the Competition Commission of India, which relied on the internal emails of Amazon, they said that the real objective was to get control of the Future Retail Limited (FRL). However, this aspect of the relevance of FRL to the overall transaction was not disclosed properly, let's say, or in so many words, in the form which Amazon had filed before CCI for seeking its approval. As a result, CCI has penalized Amazon to an amount of INR 2,202 crores. Why I say this is an important element is because this is the first time that the CCI has been willing to reopen a combination order. Prior to this, CCI has been absolutely reluctant to have a relook at its combination orders. It was very simple. The reason was very simple. Initially, if you see the history of competition law in India, 2002 the act came. It took good 7 years for the antitrust provisions, that is abuse of dominance and anti-competitive agreement provisions, to be notified. That was in 2009. It took further 2 years for the regulations with respect to combination, that is mergers and acquisitions. So the regulations and the relevant provisions, section 5 and 6 of Competition Act, were notified only in 2011. The reason was the industry was very concerned as to the effect that this new regulation is going to have on business, the conducting business in the market, on the M&A transactions happening in the market. And there was a lot of opposition. And CCI decided that at that time, and CCI had said this in public domain as well, that look, we'll be very gentle in the way we enforce these regulations. We will ensure that the transactions get approval as soon as possible. As a result, if you see, since the last 10, 11 years, CCI has not rejected a single combination. It has approved all proposed combinations which have come to them. They have imposed certain remedies in some of the cases, but these are very few and far between. CCI has also gone further ahead, and CCI has made, provided exceptions with respect to when, even though you may be a combination and technically you may require filing, but certain exceptions have been provided by CCI, by which you don't need to go to CCI and take the approval. CCI has given a green channel route by which the companies can decide themselves whether the transaction is going to have an anti-competitive effect or not. If they conclude that there's no anti-competitive effect, there is a approval, automatic approval, which has been given by the Competition Commission of India. So there is an element of trust that CCI has built with the industry, where they have given them, they've tried to say, look, boss, we support your assessment as well. So as a result, CCI till date, till the Amazon order, had refused to have a relook at any of their orders, combination orders. Once they had approved it, they said nothing doing, we are not going to look at it. In fact, I remember one of the cases where BGI Energy had challenged the combination between Hitachi and Mitsubishi, and the matter went to CCI first. CCI refused to look at it. It went to the NCLAT first. Unfortunately, because of the limitation, NCLAT refused to look at it. High Court, when matter went to High Court, where High Court said, look, and the issue before High Court was whether inspection can be granted to parties who are challenging a combination order. High Court said, look, inspection can be granted. Based on that, you can take a call on whether or not to have a look at this matter. And even before the High Court, CCI opposed this petition tooth and nail. So they have shown a very strong reluctance to reopen and have a relook at the combination orders. It was only in Amazon that they have finally decided to have a relook at a case and penalize the parties. And interestingly, every combination order that you see before CCI, coming from the CCI, the last paragraph always is that if any information or data provided to us is incorrect, is found to be incorrect, then this whole order is void, ab initio. The whole order does not stand. So as a result, you see, even in this case, the Amazon order, CCI has not only penalized Amazon, it has also asked Amazon to do a refiling in Form 2, which is what we call the long form, which requires a lot more data than the Form 1, which is the short form, which Amazon had filed earlier. So a lot of pain for Amazon as a result of this order, and a watershed moment for the Commission, where this now becomes a precedent where CCI is willing to look at its combination orders and reassess what was the data that was provided to the Commission while analyzing and approving the transaction. Something interesting has also happened with respect to how courts are dealing with competition law. And we see a very distinct pattern that courts are reluctant to interfere with the investigations that are going on before CCI. They are willing to hear the issues that the parties are raising, but they are not willing to impose a stay or issue a stay with respect to investigations. So they say, let the investigations continue. Whatever issues you have, you can continue arguing. And we can see some of the recent cases where Amazon Flipkart case, it was challenged before Karnataka High Court, and then it was challenged before Supreme Court, and both Karnataka High Court and Supreme Court said there's no need to stay the investigation. Whatever issues you have, you argue. There's no problem. Let the investigation continue. This must be seen in the context of the previous case of the cartelization, alleged cartelization in the telecom industry, which was information was filed by Jio, in which CCI had ordered an investigation, which was challenged before Bombay High Court, and Bombay High Court had decided to say, look, there is some problem, and there was a stay granted on the investigation against the telecom players. And this went right up to the Supreme Court, where again, the Supreme Court, for some very valid reasons, said, look, this is a issue which first the sectoral regulator, that is the Telecom Regulatory Authority of India, should first look at, and only then should Commission look at it. So there were certain reasons there as well. But now we see there is a very clear reluctance by the courts with respect to granting stay on investigations. These are not being granted now. We have seen the WhatsApp case recently. WhatsApp went to Delhi High Court and say, look, stop the investigation. We have certain concerns about the data being asked for. Delhi High Court said nothing doing, let the investigation continue. Similar with the tire cartel case, which the tire manufacturers had challenged before Madras High Court. Recently, the appellate court at Madras High Court, the appellate bench on Madras High Court, again decided that no need to stop the proceedings, let the proceedings continue. So we see that very clearly, courts have decided that they are not going to intervene in these proceedings. What are the problems that are being faced? And this is something that they have faced for quite some time. One is shortage of staff. There was this initial study by IIM Ahmedabad, where they said the CCI will require a staff of some 500 people. They've never got that kind of staff. They don't have that kind of manpower uh, to support them. So that is a problem that the commission has been facing. Second is that the investigating officers who investigate these matters sometimes lack knowledge of evidentiary law and economics. Now, to give you an example, I have come across one case, at least one case, where when I look at the statements of three witnesses is identical, right from the full stop to the comma. Everything is identical. Three witnesses who gave the statements on three different dates. So you realize that the person who was taking the statements was not doing a good job of it. He was doing something funny. And you realize because of this one mistake, the whole investigation is now in trouble. So lack of knowledge of evidence is a problem with Competition Commission of India, especially with the Office of the Director General, which is the investigating arm of the commission. Second is economics. The way I see it, it has two facets. There are two different trends that we see. One is, of course, that at the DG's office, some of the officers are not very well trained in economics. But when we consider CCI's orders, CCI over a period of time has shown an increasing acceptance of evidentiary value of economic evidence. They have been willing to get into economic analysis and come to a conclusion based on those analysis. Initially, we saw initial orders. If you see initial till 2000 from 2008, 9 to 2014, 15, I'll say the reliance on economic evidence was very limited. However, that has changed now. When Somsa was talking about the infrastructure tribunals, and that's when I started thinking about the tribunal, the appellate tribunal for Competition Commission of India, that is NCLAT. And I agree with him. There is a problem with respect to the requisite staff at the tribunal level. Now, yes, we talked about the staff required for CCI, which is good 500. And you have economic experts, you have experts on different issues out there. The experts from Competition Commission go and work with other regulators. So they learn about other sectors and then they come back and serve with Competition Commission of India. So they have a very good knowledge bank. However, if you see, compare this with the NCLAT, NCLAT has no such infrastructure. You have a judicial member, you have a technical member, two technical members, but you don't have the requisite experts who specialize in competition law or economics. So the tribunal has been facing this problem with respect to competition law as well. And this is something that needs to be addressed and looked at. Thank you. Any questions?
If anyone has any questions, you can post it in the chat box. Sir, we'll wait for 2 to 3 minutes. If anyone has any questions, I hope that's
Sure,
okay.
sure.
I don't think anyone might be having any questions. Okay. So, sir, thank you so much. I thank you on behalf of MNLU Mumbai for being the part of the national conference today.
Thanks for having me.
Thank you so much, sir.
Thank you. Take care.
Yes, sir. Moving further with the national conference for today, I would like to invite the speaker for the next technical session, Ms. Kajal Krishna Iyer, ma'am. Ma'am is an independent journalist with more than 15 years of experience in television and new media, and had also served as the bureau chief of the national channel. Notable things that ma'am have covered are 26/11 attack, the trial of David Headley, and the election in around 12 states in India. Ma'am is a multilingual and also pursuing the law degree as well. Ma'am, I welcome you on behalf of MNLU Mumbai.
Yeah, hi. Thank you for this invite, and I hope everyone is having a good time. What with all the news that is coming in with respect to COVID and all, I hope all of you are well, and all of you are also pursuing your law degree as best as possible, just as I am trying to grapple with this entire way of studying law while still sitting at home. Okay, so I have worked for more than 15 years in broadcast television and also have written for several things. And the topic that I have been asked to speak on is about the trends in media. Now, I don't want to talk about generic trends. I would like to talk about trends that are, that have some sort of a impact with a law per se. Now, there are two, three emerging trends the way I see it. One is, of course, the fact that the frequent challenges to the freedom of speech and what exactly constitutes freedom of speech and what exactly is going to be something that can be justiciable and can be seen as not a part of freedom of speech, because remember, the constitution says that your freedom of speech has certain restrictions. Now, this is the frequent aspect of media that comes in conflict with the law, be it by individual petitions, be it by institutional petitions, be it in the form of defamation suits. All of these aspects do come up quite a bit, and I'm sure all of you have studied some of these aspects in not just your classes on torts, but also in your practical sessions with respect to law and advocacy. So, what I would like to touch upon is that there is an emerging challenge that has come up now with all these kind of things, especially with respect to the emergence of social media as one of the viable alternatives to mainstream media. When I say viable, I am talking mostly about the way in which social media has also become a way for people to spread information and a lot of times even disinformation and earn out of it. There are YouTubers dime a dozen now. There are several Twitter handles. There are certain, Facebook pages, all of them publishing information, publishing videos. And some of these are run by former journalists. Some of these are run by people who just have an interest in the areas that they are good at. So this is where one of the major conflicts right now in media and law is emerging, because how do you police things on the internet? That is a huge matter of a discussion right now. The draft rules which came into existence eventually with respect to policing social media have also faced a lot of flack from news organizations, because it put news organizations and also those who were in commercial ventures on the same platform, and that led to a lot of friction. There were a lot of representations that were made to the government with respect to the rules regarding the internet. But one thing that no government across the world seems to have figured out is how to bring disinformation under the ambit of the law, because currently the way we see it, we see that a lot of disinformation goes on, and the platforms that are on which this disinformation is hosted, be it Facebook, be it WhatsApp, be it Twitter, all of these platforms are also seemingly, or at least that is a representation that they are making to various governments across the world, that they are not able to actually control these, and they are not able to run the kind of algorithms that initially they would have wanted to run to curb all of these things. This is leading to a lot of issues. For example, the latest case that has happened is that of the bully by deals. Now, if all of you know what GitHub is an open source platform that allows you to create apps and websites of your own. And what this group of youngsters did was that they created an app to auction Muslim women on it, and then they started propagating it on various social media like Twitter and Facebook, etc. Now, the problem that the law enforcement agencies come up with is a very unique one, because before Bully Bai, there was something called Suli deals. A case had been registered under the Delhi police in this particular case also, and it was very similar. An app had been made. Only in this case, the app had not been propagated so far. And what had happened was that the Delhi police wrote to GitHub, which is owned by Microsoft, and GitHub said that, look, we cannot share information just like that. You have to get a court order for this. And so far, what we have seen is that cases of online bullying, online harassment are not really on the top of the priority in hearings and in listings in court. Now, that is something that has not really been addressed adequately so far. Only if there is someone really powerful or someone really famous involved do these cases come up for listing as quickly as they should actually. There is a generic sense in the law enforcement, also in courts and amongst lawyers and amongst judges, that, kya hai, it's just some post that has been written, it's not as damaging. But the virality of these posts and the way they spread across is actually making them much more potent than, say, a defamatory article in the newspaper, because newspapers have a very limited reach. There are only so many people who would have read that newspaper on that particular day. But if something is on the internet, the virality is something that is uncontrollable. So what had happened in this particular case was the Delhi police could not get GitHub to actually share the information. And eventually what happened was that a few months passed, some of the same kids eventually started another app of the same kind. So law which should act as a deterrent, law enforcement which should act as a deterrent, could not act as a deterrent, because there is still a lot of back and forth that comes to it when internet companies that are headquartered in other countries are asked to submit or furnish details about things that are happening on their platform. One of the main reasons why the new draft rules were actually promulgated was because they wanted to bring these companies into the ambit of the Indian law. Uh, while those aspects of that particular rules were very well thought out, there were certain other things with respect to news publishing that made those laws very, very contentious. And these are questions that will keep on coming up. One of the things that the courts, the lawyers, and the government and law enforcement establishments need to realize actually is that the internet is not going away. Misinformation on the internet is not going away. And so one has to become smarter and smarter in ways to curb it. Of course, around, say, 10 years ago, we would never have thought that we would have needed fact checkers on the internet, but now that is the reality of life. The way forward, according to me, is that these people who were employed as fact checkers, which is already happening in some cases at least, that the local police is tying up with these fact checkers to try and find out what sort of information is going around and what should be curbed. So in some small ways, this experiment is being done. Say Alt News, Boom Live, all of these fact checking websites have from time to time actually got into small scale tie-ups with the local police with respect to certain cases, because these websites and these institutions have experts who can backtrack things on the internet, which the police might take some time into. Though the cyber cells have been put into place in most of the states, the quickness of the search and of the backtracking is not as much as some of these websites are. So why this becomes more and more important is that these days the kind of information that is being shared on the internet and through media is something that can actually attract 153, section 153 of the IPC with respect to inciting violence and inciting unrest in the community. Now, that is one aspect where initially the law could not catch up with respect to social media and stuff that is published even by news publishers on the internet. But now, given the fact that the reach has almost doubled, tripled, it is very, very important that the ambit of all these things become justiciable, and also that Section 153 can be easily imposed on all of these activities that are going on the internet. So these are some of the aspects that are there. With respect to another thing that I would like to talk about is the way law and courts are being reported. Now, there has been a sea change in this particular aspect compared to earlier. The way it used to work out earlier was that there would be a reporter who would go there to the court every day. They would check out the list on the notice board of the cases that are put up, go to each court one by one. In fact, in lower courts like Sessions Court and all, the reporters do that even today. They go physically to each of the court because these listings of the cases are not available online. So you go physically, you check the board or outside each court, then you figure out what is the important case that you need to hear. Then you are physically present at the court there, and you write it down in your little notebook, and then you go back, you read, you cross-reference with any of the law books or any of the lawyers who were present there, and then you prepare a report. What has happened now is, at least in the past few years, is that a lot of the listings at least were made online. So you didn't have to physically go and check. You knew where, in which court, which courtroom, what case was going to be heard, and then you just ended up going there. What hasn't changed in this entire aspect of reporting from the courts is your physical presence. You have to go to the courtroom, or you join the link that has been provided for that particular case. Now, here is where it gets tricky. Ever since the pandemic, because you cannot go physically, and only even when the courts are open, there are very few people who are allowed in physically. The entire power on who is being allowed into that link lies with the registrar. And a lot of times we have seen, like 2 days ago, there was an incident where in Nitesh Rane's hearing that was happening, all of the reporters were removed from the link. Now, what happens is that this gives undue power to the registrar or to the shiristadar who's there sitting there in the courtroom, who is handling that particular link, as to who they can let in and who they cannot let in. And what happens is that this ends up creating problems for the reporting of the event. And other than that, also there is a lot of distrust and mistrust that seems to be there amongst lawyers and journalists, amongst judges and journalists. Some of it born out of this feeling that judges and lawyers have, that we know the law. Most of these people are journalists who have not studied law, which is not true. A lot of the journalists are actually LLB graduates. Some of it born out of, the one or two bad apples who end up misreporting something, and then, the judges and the lawyers lose this thing. And some of it because there are certain accused and certain lawyers who want to take advantage of this one aspect in law, which is called an in-camera trial. Now, there are times when that is justified. For example, a lot of the POSCO cases are in camera. Now, that is justified because a child will not be comfortable to speak in front of so many strangers about what was perpetrated on the child. So in cases like that, it makes sense. In cases where there are probably issues of national security, it may actually make sense to have very few people, and then whatever is reportable to be provided in terms of affidavits or in terms of orders, and that can then be reported. But what is happening is that because of various reasons, a lot of blanket bans are being put in. For example, recently there was an order by the Bombay High Court with respect to reporting of sexual harassment cases. Now, that sort of reporting actually makes it, that sort of ban on reporting actually makes it virtually impossible for people to come up with anything. The order that actually said, the order said you should not be naming the victim, which is already there in the new law of sexual harassment. You should not be naming the perpetrator either. Now, as a journalist and as someone, as a responsible citizen, I see where it is coming from. They probably don't want the perpetrator's name to be out until he or she is convicted. But in this case, the order actually says that it should never be named at all. Now, this actually might not act as a deterrent, according to me, because, if someone is a serial offender in terms of, and sexual harassment now also includes sexual harassment at the workplace. It need not be rape. It could just be, verbal sexual harassment that a person puts, or general things like pawing or touching without consent. Now, if there is someone in a work-like situation who is a serial offender in this, and every time there is a case, because of this order by the High Court, which says that you cannot name the perpetrator, this person could continue going on doing things, and no one would be the wiser. He could keep getting. He or she, I mean, I do not take away that possibility away. He or she could actually get more jobs, because nothing is ever going to come on the records. The order also says that no one can get a copy of the of the order even, and the order will not be uploaded also unless someone actually goes to the court and applies for that particular order. Do you expect that HRs of companies will actually go and apply to courts for orders regarding, or regarding any person that they are hiring? So there are certain balances, that there are certain checks and balances that need to be applied. But what one is seeing is that there is a lot of protectionism amongst the courts, amongst lawyers, amongst judges, that seems to be happening, which is out of which makes it very difficult for the society to access what is happening in courts. And that is where the reporter actually comes in. The reporter is the person who goes there to the court. A common man cannot keep track of all the orders, everything that is happening in court, everything that could end up being a precedent. But when a reporter reports on it, it's there out in the media for the public to consume whenever they want. It's there on the internet for them to search. It's there. Now you may come up with saying that, oh, there are law journals, there are other things where these things are reported, but that is not something that the common man has access to. A common man will not have neither the time nor the ability nor the money to have a subscription to, say, an SCC Online or a Manupatra. So he or she will rely on what is being reported on the mainstream media, which is why when these kind of orders are coming in, something that the judges and the lawyers need to actually think about is, are they killing the reporting of that particular section or that particular case completely? Because that is not in the interest of the society at large. That is something that judges and lawyers need to think about before they come up with orders that are completely blanket. And I would like to mention that a lot of these orders for in-camera proceedings, or at least applications for in-camera proceedings, sometimes come from the accused with an ulterior motive. There are at least two where, as a journalist, I was part of, where we challenged the application that was given and the order that was passed by the lower court for in-camera proceedings in the Bombay High Court, and we successfully defended that. One was in the Sohrabuddin case, where one of the accused said that he wanted the entire case to be an in-camera trial and no reporting to be done. And this was at the stage when Mr. Amit Shah, the current Union Home Minister, was still considered to be an accused. He was eventually let off in that particular case, when he was still considered an accused, this sort of a move for an in-camera trial was moved. An application was moved, and we had challenged it successfully. A group of journalists. We went to the Bombay High Court. We got an order that we needed to be heard, and the High Court eventually overturned the lower court's verdict. A similar thing happened in the Malegaon blast case, and here also one of the accused approached the court saying that they did not want uh, the trial to be reported on. Again, we had to approach the Bombay High Court, and a favorable order had been given in this particular case. What's interesting is that there is no bar on how many times people can apply for an in-camera trial, because now another accused has once again gone to the earlier in the Malegaon case, it was the NIA that had gone. Now one accused has gone just recently asking for an in-camera trial. So all this comes at a time when, in countries like the US, a lot of these trials are actually available. Everything of the trial is available for the public to access, which is one of the reasons why you see a lot of these crime podcasts and crime shows and all of that in the US, which are very, very well researched, because the trials are available in public. You can apply to the court and get even video footage of the trial, which all of the trials there, by the way, are recorded. During the pandemic, some judges, of course, have decided that they will try to make legal access more accessible. One of the interesting experiments done by the Gujarat High Court is that they put up their daily hearings on YouTube. And you can now go on to the YouTube channel of the Gujarat High Court and hear their daily proceedings live going on, because the court, of course, is functioning on a virtual basis. So that is a welcome step. There are also steps that are being taken by the government and others. The Supreme Court is also mulling that the link for these hearings should be made more public, and not just that, even once the pandemic subsides and there will be physical hearings at that time, also a live broadcast if that is possible. So this is something that is being mulled over. One thing that a lot of judges and some lawyers are really miffed about is the aspect of live tweeting. Now, this was a new phenomenon that started around 3-4 years ago. First started with some of the lawyers and some of the journalists in the major high courts and Supreme Court, like Bombay High Court, Delhi High Court, and the Supreme Court. They started tweeting about the proceedings themselves. Now, this has been a bone of contention, because there are people who think that a couple of lines from the order gets viral, and then it gets taken out of context. That is one school of thought. However, the other school of thought is that live tweeting has actually made legal proceedings more accessible to a wider audience, and has promoted understanding of law amongst a larger number of public who are active online. So a lot of times I have seen that youngsters who are interested in law, or even college students who have not yet made up their mind about law, when there is an important case, even UPSC students, and they will be following bar and bench or live law and tracking the entire proceedings on their own. This gives a certain sense of agency to people for them to understand things. A lot of these live tweets are done very, very well. I know some of those people who actually work there. They quote the correct sections, they quote a lot of details from the orders, and then a student or someone who's interested in knowing more can just actually look up those sections, look up those previous cases which are cited, and understand the order and the proceedings even better. So live tweeting is something that has really changed the way reporting on law has happened, and also how people are accessing it, and that has really brought in some amount of universality in understanding of what exactly goes on in the courtroom. Um, um, uh, since all of you are law students, it would not be very difficult for you to understand. But I do recommend all of you watch Chaitanya Tamane's court, because there would be a lot of you who would not have attended any court before you started this particular course. And while the usual understanding that people have, of course, is what you see in Bollywood films, where there is, there is one Kathkara and there is one judge sitting high up top, and there are all these dramatic flourishes made by the lawyers. That's not how proceedings go. Chaitanya Tamane's court actually shows what goes on, how tedious, how long drawn it can actually be. But at the same time, at the center of it all is justice, and at the center of it all, when a reporter reports on a proceeding, what they also want is to propagate the fact that justice still exists in this country. And um, one of the things that I feel lawyers and judges need to keep in mind is that more of a reporting of the proceedings actually only leads to more building of trust in the public, in the legal proceedings. And that can only help in building the profile of the legal profession in the public mind. Already the only thing that people trust in our country, the only institution that where people still have trust in this country, is in the legal I'm sorry, can you see me? Yeah.
No, ma'am.
Sorry for the interruption. So sorry for the interruption. I got a call. So that is something that will only lead to more trust and more confidence in the legal proceedings, and that is why lawyers and judges should not see the press as their adversary, but they should actually give out information so that more and more people can understand and access law, and this fear that people have about legal proceedings can be removed. Thank you so much.
Thank you so much, ma'am. It was a privilege having you with us for the national conference today. Thank you so much.
Thank you.
So we will have a lunch break now. The next technical session will begin at 2:30 p.m. You can rejoin by that time.